Welcome back to another edition of Between Two Fars. I'm Warneke Miller, and I'm here once again with Andrew Falcon. He's been talking with us about the lawyer's role in risk mitigation. Andrew is a phenomenal attorney who's got over 30 years of experience, most of which has been here at NASA, and since 2012, he's been the chief counsel over at Goddard. Andrew, thank you so much for joining us again today. I'd like us to focus our conversation today on the mitigation of risk in contract claims. This is an area that just liability. I mean, that's what contract claims are. That's risk right there. That's liability. How do we consider risk mitigation in this forum?
So the first thing I think we need to really address is how do we defend claims in this forum, right? I mean, because they're kind of the redheaded stepchild of the legal practice, right? I mean, even within the procurement world, protests are much higher visibility because, of course, it delays contract award. Claims, which may be much more consequential in terms of both ramifications, because let's face it, you get a protest, you're just going to extend the existing contract, right? I mean, the impact may be less than people think it is, as opposed to, actually having non-complying deliverables or something like that, right? So it's pretty important to wrap our heads around the fact that from the impact, it's significant, but also from legal workload, right? Because it's not a record decision. You have depositions, you have interrogatories, you have a trial, you have post-hearing briefs. All that stuff is has a huge impact on legal workload. So, and we don't get so much of them that any of us are really experts at it right now. I know you have an Air Force background where they can afford to have, like experts who do nothing else because they're so big. We don't have that. So how are we going to manage that? That to me is job number one.
Do you have any ideas about the best way to manage this risk? What would be your optimal solution for something like this?
Well, I can tell you what the worst way is what we got right now, which is literally, I have to make 10 phone calls around the agency begging for help and seeing if there's something I can trade with some other chief counsel or AGC to get that help, right? That makes no sense. I mean, the barter system is not the way to run a modern legal practice. So how do we institutionalize it? I guess that's really the question, right? How do we set up the kind of support structures that we need to identify expertise that is available and deploy it? And so I think the claims group is a great start, right? We've never had that before. If I were going to point to the handful of the very short list of good things to come out of MAP, that would be one of the top things on my list is the claims group. I think, even more so than, the broader CLFs, right? So I think this is a good step in the right direction, but how do you deploy that talent where it needs to be? I mean, because it's a huge commitment, and that means you got to start with supervisory engagement, and then you got to get through workload management. And is there something that we can provide to back up the attorney who's being deployed to help out, and so on and so forth? All I know is that, I don't think we're going to be able to continue to be individual centers handling all our own cases on our own anymore. I think the cuts are going to be too deep.
Yeah, I have heard some people suggest that we settle more. What are some of the risks to simply settling out all our cases rather than putting the manpower in to litigate?
So the problem is settling doesn't necessarily help, right? I mean, I'm talking to an audience of lawyers who tried cases before. Half the settlements I've ever done in my life have been post-trial, right? And then you're not settling to save labor, you're settling because you got a serious problem on your hands, or the other side has a serious problem on their hands. But whichever, once you get an actual transcript and you've got your impression of how the judge handled that, hearing and so on and so forth, the handwriting is now on the wall. That's when I would say a majority of my settlements historically have taken place that late in the stage. So there's no labor to be saved. And besides which, are we zealously advocating on behalf of the client, as required by the ABA model code and presumably all of our state bar licensing authorities, if we're just like, oh, we can't defend that case, you have to settle up front, right? Like, I mean, I really think, you know, the attorneys on the other side are private sector law firms. They're not looking to cut the resources that they're spending on that case, you know. So yeah, I think settlement is it's a nice idea, but it doesn't solve anything.
Yeah, I think one of the other theories that I've heard, and I've actually seen play out going from the Department of Defense to NASA, is that when you've got a reputation for settling early to avoid conflict and avoid the manpower issues required to litigate, that the contractors do get very pushy and you end up paying a lot more for things that you're not liable for. You end up paying a lot more on your contract, and then you may end up getting caught in the audit or other areas where you're called to task for inappropriately spending taxpayer money.
Well, and more importantly, you haven't been a lawyer, have you?
No.
Right. I mean, the whole reason we exist is to defend the agency in litigation, right? Like all that advice and counseling stuff, that's great. But if you come down to one core function, it's defend the agency in litigation. That's what lawyers do. So yeah, so you have to do that. But and yeah, you probably do get a bad reputation because we all know the contractors talk. I mean, I certainly know at Goddard the gossip circle amongst contractors is cray cray. So if did I date myself with that? I can never tell. But I think, you know, that's something that you probably have to consider as well. So that's a very good point.
Yeah. Well, I really appreciate you taking the time to talk to us about litigation risk and liability, and particularly our claims division here. Thank you so much for your time. I would like to get some of your more global take on the attorneys and the mitigation of risk. Would you join us for one more episode, Andrew?
Oh.
All right. Stay tuned for the next episode. There's dating myself. Stay tuned for another episode of Between Two Fars.